number 15. It may be Cagle or Cagle, we'll find out, versus State of Maryland. As soon as you're ready. Well, good morning, Mr. Ball.
Good morning.
Have I mispronounced your client's name?
It is Cagle.
It is. Okay, thank you.
Morning, Your Honor, and Your Honors. My name is Chaz Ball, and I represent Wesley Cagle. May it please the Court. This is a case about technology outpacing the rules, about a preclusion of what's ultimately evidence, and as a result of that, a diminished final plea. Obviously, our entire system is about ultimately getting things right. You know, it's not a perfect system, but it's a system designed in which we are trying to get to the result based on incidents that took place in the past. The entire trial system is to try to sort of suss out information from the past to try to determine what is the truth, what happened. In this case, Wesley Cagle was an officer of the Baltimore Police Department on December 28, 2014. He was called to the area of 3001 Monument along with other officers. When he was called to that area as a result of a burglary call or a call for service, he responded to that location with other officers, and the testimony that came out in the course of the trial was that Officer Cagle went towards the back of the building, and other Officer DeBrasi was in the front of the building. Officers Leary and Smith were towards the side of the building. Officer DeBrasi called out for the individual inside wearing a mask coming towards the back or coming towards the side, and when the individual opened the door, Officers Leary and Smith fired. Officer Cagle at some point afterwards walked from that area towards the rear of the building towards the side, and ultimately at some point fired at Mr. Johansson as well. And that was the sort of factual background of it. But when we get to it, we get to razor-thin factual analysis for what's the ultimate questions there. The Garrity standard of an officer being able to use deadly force if he's in a deadly threat situation, if he believes that his life or the lives of others are in danger. And so the testimony that came out in trial was that Officers Smith and Leary, who believed that they were in a deadly force situation, who ultimately fired, they were unable to see Mr. Johansson's upper body as Officer Cagle approached. They were unable to see exactly what he was doing as Officer Cagle approached. And while there was a distinction, a difference between what Officers Leary and Leary and Smith and Officer Cagle said as to the distance Mr. Cagle was from Mr. Johansson, there was no question that they couldn't see the upper body. They couldn't see what Mr. Johansson was doing. Mr. Johansson said that he wasn't moving his hands in any furtive way. Officer Cagle testified that Mr. Johansson was moving his hands in a furtive way. And Officer Cagle fired because he felt that there was a threat that was there. And that was the evidence that was presented. And this was a case, importantly, that when it was tried, it relied very heavily on that eyewitness testimony, almost exclusively on the eyewitness testimony. There was physical evidence that was presented, but there wasn't a question about Officer Cagle firing his weapon. There wasn't a question about Officer Cagle actually firing at Mr. Johansson. The question that was presented, and really the issue that had to be decided, was sort of on that razor-thin factual distinction. Was there a threat presented by Mr. Johansson at the point at which Officer Cagle fired, or was there not a threat? If there was a threat, then Officer Cagle's not guilty. If there wasn't a threat, then he is found guilty. Ultimately, Officer Cagle was found, Mr. Cagle was found guilty of first-degree assault and use of a handgun in commission of a firearm, use of a handgun in commission of a felony or crime of violence, and not guilty of first and second degree attempted murder. In the course of the trial, prior to closing arguments, there was an attempt by trial counsel, defense counsel on behalf of Officer Cagle, to use what is testimonial evidence, evidence that's presented in trial. And obviously, in trial, there's two types of evidence that's presented. There's documentary evidence and there's testimonial evidence. There was an attempt to use testimonial evidence, recordings from the trial court, in closing arguments in order to display sort of differences in the testimony of Officer Leary from different points, Officer Smith from different points, and inconsistencies with Mr. Johansson at different points.
Was there here a package of videos that you or whomever was representing Mr. Cagle at the time? Was it multiple individuals' testimony? I didn't quite get the drift of that. If you could clarify for me. That's
correct. There were testimony. It was video of Officer Leary's testimony from trial, Officer Smith's testimony from trial, and they were separated. But there were specific segments of the testimony that was being utilized, as well as Mr. Johansson's testimony from trial and a short portion as well from the Officer Detective Meinhardt, who was the technician who did the ballistics testing on it. And so,
Mr. Ball, I too was sort of unclear. The record shows that the trial court judge reviewed what was being proposed for closing argument, and I think it refers to that as a PowerPoint. Was the closing argument a PowerPoint that the trial court judge reviewed?
It was saved on a PowerPoint just for convenience of pulling up one video and then being able to pull up the next video and then being able to pull up the following video. So it wasn't a PowerPoint in terms of there being slides or there being information that was being presented in it. It was a PowerPoint for the standpoint that was how the videos were packaged together, as opposed to being separate videos that had to be brought up one at a time.
And it wasn't clear to me whether these are actual video testimony at trial or whether it's audio testimony from the trial with perhaps a photograph of the individual.
This was actual video testimony from trial. So the actual videos, and I believe, as it's sort of discussed in the record, and I guess it's not completely clear in the record from the trial court, but these are actual videos from that are taken for the preservation of the record of trial of the witness testifying. So video and audio recordings of those specific witnesses, Officer Leary, Officer Smith, as well as Mr. Johansson.
But it appeared that there was some production techniques used in the PowerPoint or in the video. At one point it says that text was typed across the top of the video to emphasize what one of the witnesses was saying.
That's not correct. There wasn't any emphasis that was given as to there wasn't anything additional other than the videos themselves, and they were merely put into a PowerPoint presentation in order to just create an ease of access, for the purpose of judicial economy being able to pull up one video and then click and go to the following video and then go to the video after that.
Counsel, doesn't our case law suggest that the trial court has a certain level of discretion relative to regulating closing remarks, and as part of the balancing of certain factors, didn't this particular judge allow you to summarize or present it in another fashion?
There is certain discretion that's given. The question, though, and the important factor that we have to look at is trial testimony is evidence. And in the same way that documentary evidence is evidence. And while there are factors of judicial economy, a judge can absolutely have the discretion and does absolutely have the discretion to say, closing arguments can be an hour or 2 hours or 30 minutes, within some range. here, the issue isn't that there's, no discretion that's there. The issue is that it created a preclusion of using evidence in trial, evidence from trial. So in the same way that I don't believe that any, trial judge would say, you have a document, you have a medical record, you can't hold that medical record up and say, look at this. It's the same type of idea. And the fact is, the closing argument of counsel is merely argument. It's argumentation. There's the jury is told that what counsel says in opening statements and closing arguments is not the evidence of the case. The evidence is what's being presented within the four corners after the opening and before the closing argument. So there's a difference between a counsel saying, this is what was said before. This is what this witness said before, and being able to show the actual testimony from the witness. Just as there's a difference between counsel saying, this is what the medical record says, or this is what this report says, or this is what this other document says, and being able to show that document to the jury. One is evidence. One is actually showing the jury a piece of evidence, letting the jury actually get and listen to the piece of evidence. And the other is argumentation by counsel, which the jury is specifically directed is not evidence.
Were these excerpts, are you considering these excerpts evidence in the case?
They were evidence in the case.
Could the jury have taken these excerpts back to the jury room for deliberation?
The jury absolutely could have had the ability to look at video of the trial testimony that was there. We have...
No. I'm talking about the videos that were being used for purposes of the closing argument. Could they have been submitted into evidence and then given to the jurors to take back for deliberation?
I'd say yes, but there's a caveat to that yes. And the caveat to that yes is I do understand, obviously, there's a rule of sort of completeness of the record. So I don't believe that the trial court would send back certain snippets of videos from trial testimony and not say, if you want to hear the entire direct examination and cross-examination of this witness, I'll send you the entire video. The court absolutely has the ability to send back the entire video. So I think that's the caveat that I would have to that yes, where these snippets, that part of it would be part of the record and would be part of the record that could be reviewed by the jury, but it wouldn't be, I don't think a trial court would send back just those snippets of the record just because, in the same way that in closing arguments, if counsel were to have a blow-up of a specific line from a medical record, I don't think the trial court would send back the blow-up, even though it is part of the evidence in the case, part of the evidence that the jury would be able to look at. I don't think it would be sent back in that sort of magnified way.
Is it your argument, Mr. Ball, that the general rule ought to be that when counsel, defense counsel, or the state for that matter, in any given criminal matter, should be allowed, given 21st century technology, to do what you did and then to offer it to the judge? What is the limit of discretion? Or are you saying instead, under the peculiar nature of this case, it was an abuse of the judge's discretion not to have allowed you to present during closing argument the videos that you put together?
I think it should be the general rule. This is allowed to be used. The video of certain segments of trial should be allowed to be used. I know it's been used by the state before. It's been used probably by defense counsel successfully at other times. I don't know any specific examples of it, but I know for a fact it's been used by the state before. It should be able...
When you say it,
excuse me,
something very similar to what
video
you...
segments of testimony. There have been cases in which this is used by the states. And one of the reasons I say that this is sort of technology outpacing the rules, Maryland doesn't have a rule on this. The Maryland rules don't say anything about it. The evidentiary rules doesn't say anything about it. I think that it's an important question. And it goes to sort of the nature of trial itself. Obviously the jurors are allowed to make notes. Jurors are allowed to, rely on their recollection of it. But understanding there's an intrusion as to the juror's time. You don't want to waste the juror's time. But the ultimate intrusion that can come from our criminal system is the intrusion into the life of the defendant, an individual having his or her name taken away or his or her freedom taken away. So to the extent we're able to get things right and allow the jury to see certain segments of the video, or if the jury were to request this part of the evidence, because it's trial evidence, as part of deliberation, then that part of it, the jury should be able to do that. And
So
it's,
you want us to overrule the cases saying that just a portion of the testimony should not go back into the jury room unless all of it is back there?
I'm not, in terms of going back to the jury room, and I don't think it says that it's all, it wouldn't have to be the entirety of trial, but it's sort of a rule of completeness. You wouldn't send back a direct examination without a cross-examination if the jury were to have requested segments of the video. But the issue is the question of whether counsel, as part of closing, which is that last plea, that last attempt, that last opportunity for defense counsel to say that there's some reasonable doubt, that there's some reason to find not guilty, that counsel should be able to use every tool at his or her disposal. And part of those tools is the actual evidence in the case. That testimony is the evidence of the case. And given that we do have this ability to review these videos, given that we do have the ability to get these videos on a daily basis, there's no reason for it not to be used. In sports, we have the ability to have a replay. In baseball, football, basketball, they have replays, and the individuals who are making those decisions are trained and paid referees who every day go in and look at different scenarios in order to make determinations. But in sports, they can go back and do a replay. And here we have jurors who are lay people for the most. There are lay people coming in and trying to look at information, and there may be things that they miss. And we're saying these layperson jurors should instead just rely on the notes that they take. They shouldn't be able to watch videos, or they shouldn't be able to be shown certain segments.
Are you agreeing then that this is subject to the sound discretion of the trial judge?
There's absolute discretion on the part of the trial judge. There's no question about that.
Where did the judge abuse his or her discretion in this instance?
Yes, Your Honor. And because there's the trial judge in this case created a hard and fast rule, and the hard and fast rule was, I will never, under any circumstances, allow counsel to use trial testimony video in closing argument. That's a hard and fast rule that says that there isn't discretion. And the reasons presented by the trial judge specifically as to why the video couldn't be shown in closing argument was, one, that it allowed counsel to sort of highlight certain portions and say certain witnesses are more important than other witnesses. Well, that's the nature of closing argument. I mean, that's why it's argumentation to say certain witnesses, certain evidence is more important, and this is what you should focus in on. And the second aspect of that is that the trial judge said that she didn't want the jurors to believe that they could go back and just look at all of the testimony, at any point, anybody that they wanted to look at, they could, look at that video or look at that portion of the testimony. And the fact is, they can. I mean, the reality is the jurors are able to do that. Is it optimal? No, it's absolutely suboptimal, but it's no less optimal than having someone who's innocent or who is, should be found not guilty be found guilty. So
Have you looked to see if other states have modified their rules of procedure regarding the use by the jury or the exposure to the jury of transcripts of testimony?
I have not looked specifically at that, whether other states have done it. I mean, there's.
I was thinking in light of all the available technology, if that had triggered any.
I have not looked at that, or specifically if the federal courts have done it, just because the federal courts do also have systems that are very high tech.
I have the same question, Mr. Ball. You do cite other state cases in your brief, but none of those states allow an instant replay of trial testimony. Is that correct?
I don't know specifically whether those states do or not. The cases that I cite that are from other states were those that were cited in State v. Green, which was a case that talked about sort of the inverse of what we're discussing today, whether it was and this is the Court of Special Appeals, State v. Green, which was ultimately reversed on other grounds. But it referred to whether it was an abuse of discretion for the trial court to allow the playing of a recording in closing arguments of information that was otherwise found to be trial evidence.
And that goes back to Judge Green's question, which is, if there's a videotape prior to trial testimony that's been admitted into evidence, such as a police interrogation or a witness in a child abuse case, those videos would be allowed. They would be evidence. They could be used in closing argument, and they could be taken by the jury back in their deliberations.
Absolutely, and that's because those videos would be evidence, just as documentary evidence is evidence, just as testimony. But
this is an entirely different leap into videos of trial testimony.
I don't think it's necessarily. It's a different area that we're looking at. I don't find it to be a leap. Trial testimony is what we rely on for the most part in our cases, civil or criminal. So trial testimony is part of the evidence in the case. It's just as much evidence as any document is. And just as much evidence, no matter how voluminous the documents are, you can send back 400 pages of medical records and those will still go back. The trial testimony is evidence of the case. So why should we cut it off, whether it be for closing, whether it be for a juror's request later, why should we cut it off and not allow the jury to see what is evidence in the case?
Would you place any limitation at all on the use of this type of evidence, trial testimony, or would a judge just be required to grant this request no matter what it is?
The judge could absolutely. There's still judicial discretion in time limitations. Obviously, a judge isn't going to allow counsel in closing to say, I'm going to play the entire testimony of my client again. But there's also be limitations as to aspects of it if the trial judge finds that it serves to mislead the jury. If there's a question in there or there's an answer that's immediately afterwards that's different. So if it would mislead the jury or if it was a misuse of the judicial economy, the time of the jurors, then that could be a discretion that's used. But the fact that this is evidence, it should be able to be used in closing arguments.
So only time limits, and if the video has somehow been altered to mislead the jury, if there's a question and then an answer that doesn't pertain?
Alteration, or it doesn't even have to be altered if the court finds that the video itself misleads the jury in some way. And there's other evidence where they say, you made this statement, but this statement sort of misleads the jury. And in the cases that talk about closing arguments, the judges have discretion to maintain that the jury isn't misled, by the statements of counsel. I'll reserve the rest of my time.
Okay. All right. Very good. Thank you, Mr. Ball. Ms. Williams.
Thank you. Good morning, and may it please the court. Carrie Williams on behalf of the state of Maryland. Mr. Cagle is asking this court to hold that no reasonable person would preclude counsel from playing excerpts of trial testimony during closing argument, that to do so is beyond the fringe of what is minimally acceptable when a trial court exercises its broad discretion over closing argument. Mr. Cagle's request should be rejected. For over 100 years, the scope of closing argument has been left to the sound discretion of the trial court. And on many, many occasions, this court has said that that's because the trial court is in the best position to decide the propriety of many of the decisions made about what can and can't be used at closing argument.
Over those 100 years, there have been massive changes in how evidence is created, maintained, presented in court. And then, of course, as we do in this courtroom, as we speak, we have video and audio recording. So I get your point that for decades, we leave that to the discretion of the trial judge because he or she has finger on the pulse and so on. But this is a slightly different argument that's being presented today, isn't it?
I don't think so.
Why not?
Because I think that this is fundamentally about who decides the propriety of what can and can't be used at closing argument. And that decision should be left up to the court, to the trial court. In this case, the trial court explained that over her nearly 20 years on the bench, she developed a general philosophy about the wisdom of allowing in-court trial testimony, clips of the witness actually on the stand, to be played at closing argument. And she explained that over those years, she realized that best practice is to not allow that to happen. She reviewed what defense counsel proposed to play in this case, and the specifics of those in response to Judge Getty and Judge Watts' question I'll get to in a minute. But she reviewed those clips and came back and said, I'm not going to let you play these clips, and here's why. 2 reasons. 1, I don't want the jury to think that we're going to sit here all week and replay this 5-day trial and all of the witnesses' testimony in its entirety. And 2, and this I think is the most persuasive, it's inappropriate to highlight one witness's testimony over another. And she said to counsel, I all the time, and I did in this case, instruct the jury to take notes. I tell them that it's their collective memory that controls. I tell them that closing argument isn't evidence. I tell them to pay attention, and I don't think it's appropriate for you to highlight one witness's testimony over another's. And I think particularly in this case it makes sense because, as I said, the judge in this case did review the video clips that were proposed by defense counsel to play at trial. And a thumb drive with those is actually in the record. I checked this morning. And the thumb drive includes, the trial court said that there are 4 videos. There are actually 5 videos, but she gets the witnesses correct about who is in the video. There's a 38-second video of the victim being asked where he was shot. There's a 1 minute and 18-second video of the victim saying that he never, admitting on cross, that he never told the police after the incident that Mr. Cagle stood over him. There's a 25-second clip of the forensics expert. There's a 26-second clip of one of the police officer witnesses, and there's a 21-second clip of another one of the police officer witnesses. And in the course of that, so when in the video of when the video is taken of a Baltimore City Circuit Court trial, the camera cuts back and forth. Usually, it goes by who is speaking at the moment, kind of like this webcast. It cuts back and forth based on who's speaking. But in this particular case, sometimes it cuts to the attorneys, and this is not unusual. Sometimes it cuts to the attorneys for reasons that I can't explain. Sometimes it cuts to the judge when the judge isn't speaking. Sometimes it cuts back to the witnesses. And that's included in these clips. In one of the clips, the judge is speaking for quite a bit of the clips. In one of the clips, the camera cuts to the prosecutors, a close-up of the prosecutors' faces. To be sure, the trial court did not point to that as a reason to not allow these clips to be played, but it does highlight the danger of allowing the counsel to get the videotape and a piece of the videotape, a very small piece of the videotape, and play it for the jury and highlight that.
Suppose it had been a more extensive piece of the video. Would your argument be the same?
No. Oh, yes, it would be the same. No, it would not be different. It would not be different because, of course, as my friend on the other side conceded, there can be limits on time, and the whole of direct and cross can't be played. And so I think that the damage is still the same.
Ms. Williams, I want to take you back to something that I heard you say a few moments ago, that it is inappropriate to highlight one witness's testimony over another in closing argument, but in all candor, that happens every day in every jury trial, I would venture to say, across the nation. You pick what you want to emphasize and you leave silent that which you don't. So how is this different?
That's right. And let me make perfectly clear that what the trial court was saying was not that it's inappropriate for counsel to argue certain portions of witness testimony, but playing small pieces of the actual witness on the stand speaking in his or her own words before the jury is different. And it was within the trial court's discretion to find it different.
On that subject, you referred to the judge saying, among other things, in denying defense counsel's request, and to her credit, she laid everything out very plainly for counsel to understand and ultimately for us to understand. Isn't there, though, at least the potential of an interpretation that we have here a failure to exercise discretion because of the judge's reliance upon her 17 or 20 or however many years? I've always done it this way. That's the way it's going to be.
If you just...
and I don't want to put words in her Honor's mouth, but you get the drift of my question.
I get the drift of your question, and I think that your summary of one sentence that she said is absolutely correct. In the very beginning of her explanation to counsel, she said, "I do not allow under any circumstances the replaying of court testimony during closing argument." But that was only one sentence. The previous day, she had had a lengthy discussion with counsel about whether or not this would be appropriate, and she mentioned the rule governing video of witness testimony, which isn't applicable, but it was in her mind. And then she took the PowerPoint and viewed it and looked at what counsel was proposing to show to the jury. And then in her explanation, she went on, after she said, "Under no circumstances do I do that," she says, "I will only play live testimony at the jury's request," or something to that effect. That's not a quote, but this has been my practice for 17 years and is going to continue to be my practice in this case without exception. So I think that, when viewed in the context of the entirety of her explanation of why she was doing it this way, shows that there was the possibility of exceptions. She thought about whether this case might have fallen into an exception, but decided that it did not. To borrow from Judge Moylan's...
Can we hone in on that sentence you recited a few seconds ago? "This has been my policy for 17 years, and it will be my policy without exception."
And it is going to continue to be my practice in this case without exception. I think, if that had been the only two sentences that she had uttered, yes, my job here would be much more difficult. But in the context of the entire explanation of why she wasn't going to do this, she actually moves immediately after she said that into her reasons. "I don't want to give this jury, the impression that we're going to sit for the rest of the week and replay the live court testimony of every witness, nor am I going to allow anyone to play excerpts of something giving the impression that one witness's testimony is more important than another."
Both of those reasons are general statements about her policy.
As it applies to this case. And I think
nothing in either of those statements pertain to this case more than it contained to any other.
Well, but she says, "I don't want to give this jury," she's talking about this case. A failure to exercise discretion, as Judge Moylan has said in a Court of Special Appeals opinion, is not consistently applying discretion in the same way in similar circumstances. That's what happened here. She's developed a general best practice over 20 years of trying circuit court cases about whether this is a good idea. And she's decided that it really most of the time is not a good idea. And she didn't see any difference in this case that would persuade her that under these particular circumstances, it was a good idea. And I think that it makes sense because, as Your Honor pointed out, a lot of things are going to be very similar when it comes to this issue. It is excerpts of witness on the stand testimony. It certainly is going to be a snippet of that testimony as opposed to anything that actually gives it the full context of what the jury heard the first time. The damage or the danger of highlighting one witness's testimony over another is likely going to be there in every case. So the fact that it's a general reason behind her application in this case, after viewing what defense counsel wanted to show the jury, does not mean that she didn't exercise her discretion.
In the old days, before video, the lawyer would have ordered a transcript overnight or something. And would you say that the trial judge could prohibit, say counsel wanted to verbatim read the testimony of few lines, could the trial judge forbid that?
I think it would be within the trial court's discretion to decide whether to do that. I think the calculus is different because, unlike here where you could have multiple excerpts back and forth, sort of a battle of the excerpts from one side to the other, you really can't do that if you're reading a transcript. I think everybody knows how boring it is to listen to somebody else read a transcript as opposed to playing video. So I think the calculus in the trial judge's mind might be different, but the discretion is still there. And if the trial judge said, I'm not going to let you, I haven't seen this certified transcript, I don't know whether it accurately reflects, whatever the concern might be, I can see a case where a judge could properly exercise his or her discretion and explain why it is that he or she wouldn't allow that to happen. And I do want to make it clear that had this judge said, I looked at these video clips, I don't think that they misrepresent anything, I think it's fine. That also would have been within her discretion. This was something that reasonable jurists could disagree about. I did want to mention that I am not aware of other cases where this has happened. There certainly isn't any Maryland appellate case where this has been an issue on appeal, an in-court witness being, their testimony being played via video or audio in closing. It could have happened before. Other judges might have let it happen before, and that was entirely within their discretion.
Would it have been all right if the judge allowed the excerpts to be used in the closing argument, but precluded them from being admitted into evidence or given back to the jury during deliberations?
That would have been all right. That would have been within her discretion. But it was also within her discretion as they were not doing this at all. I don't think she could have let it go back with the jury for the reasons that my friend articulated. And I did want to point out that that is, I think that my friend's answer was they could have sent it back, but if they wanted to hear more, they could just ask. Well, that was exactly what the court was afraid of. That is exactly what the court was afraid was going to happen, that they were going to cling onto this one piece of testimony and then say, well, we want to hear the rest of this witness's cross. Well, now we want to hear the rest of this witness's direct. Well, now we want to hear this witness's testimony. There's no evidence in this record that the trial court had the ability to get that video. I'm not sure what defense counsel received when he got this video. He may have had the whole trial, or he may have just asked for those pieces. I don't know. It's not in the record. But we don't want to put judges in the position of having to decide how to gatekeep this particular function if in their learned discretion they've decided that it's just not a good trial practice and that they're not going to allow anyone to do it. I think that it is within their discretion to make that determination. I do want to make sure that I point out, Judge Houghton mentioned that that counsel was allowed to do other things with the evidence, just not play portions of the witness's testimony. And that's exactly right. In explaining her ruling, the judge said to defense counsel, you're certainly within your right during closing argument to reference trial testimony and to summarize it or restate it or draw their attention to it. Emphasize whatever you want verbally, but you will not be permitted to play it for them. And that's why she properly exercised her discretion in this case. My friend in his brief said that the question for this court was whether the trial court abused its discretion in not allowing defense counsel to use evidence in closing. That's not what happened, and if it were what happened, that would be an abuse of discretion. If the judge said, you're not allowed to mention a particular piece of evidence, of course that's not an appropriate exercise of discretion. But saying you may mention it in all of these ways, but just not playing certain pieces of in-court witness testimony is not an abuse of discretion.
May I ask you to address, I think you make an alternative argument of harmless error.
I do, and I was actually just going to say, but that brings me to my harmless error argument. My friend this morning did an exceptional job of highlighting the discrepancies in the trial testimony that was presented to the jury. And he did an exceptional job and additionally was allowed to play pieces of Mr. Johansson, the victim's statement to the police immediately after it happened, which was admitted into evidence as an exhibit, and highlight specific pieces of testimony and trial exhibits in his closing argument. He was allowed to make all of the arguments that he intended to make using those clips of witness testimony. He talked about he argued that Mr. Johansson never told the police in his initial statement that Officer Cagle stood over him and shot him. He told the jury that there was a discrepancy with where the expert said that the shell casings landed and what that means for the evidence in this case. He told the jury that Mr. Johansson initially said that he was shot in the groin immediately after he exited the store, which would indicate that it was actually one of the first two officers that fired that struck him in the groin. He told the jury that one of the police officer witnesses testified that he told Mr. Cagle that Mr. Johansson had a weapon. He's, be careful, he has a weapon, or something to that effect, before Mr. Cagle approached the victim. And he also highlighted the fact that the other officer never told the police in the internal affairs investigation, that Mr. Cagle said that he shot the victim and then used a vulgar term for where he shot the victim. So he highlighted all of the things that he wanted to use that video for in other ways. And the jury credited and considered some of that, because Mr. Cagle was charged with a number of more serious charges that the jury acquitted him of and convicted him only of first-degree assault and use of a handgun in a crime of violence. So I think even if this court were to find, and I would urge this court not to find, but even if this court were to find that it was an abuse of discretion not to allow this video to be played, the error was harmless because it didn't affect the jury's verdict.
I'm going to take you back to earlier in your argument. You mentioned that you referred to the one or two sentences in which the trial judge said, this has been essentially my policy. After thinking about it over time, this is what I've developed and this is where I land. Do you see any way, do you see that there is a way that makes this problematic when a judge has, I think opposing counsel referred to it as a hard and fast rule. You mentioned Judge Moylan's opinion, and I think you cited in your brief. There's an opinion of this court, different issue, jury instruction, as opposed to closing argument, where, if I recall correctly, the court had something to say about the judge's comment that this is my rule. I don't allow this.
So I think
fast rule.
I think you're speaking of Gunning.
I am.
Yes. So I find that case different in kind for two reasons. One, really the underpinning of the judge's hard and fast rule in that case was a belief that that jury instruction was a mistake of law. So, of course, if you believe a pattern jury instruction is wrong on the law, you are never going to allow it to be given under any circumstances, regardless of the individual circumstances of that case. And that is part of what this court pointed to in saying that was an abuse of discretion, because he was never going to give that jury instruction. And had he not been operating under that mistake about this, because the court in Gunning said it's actually not an incorrect statement of law. Had the court not been operating under that misunderstanding of the law, it might have looked at the circumstances of these individual cases and decided that the jury instruction was appropriate. That's not what happened here. The circumstances in this case were considered, and the court said, even under these circumstances, nothing about this case is different that would point me in the direction of making an exception to what I've developed over the years as my general belief is a best practice for conducting trial and closing argument. So I think that's why Gunning is different. It wasn't a consistent application of well-exercised discretion. It was a mistake, a fundamental mistake about whether this jury instruction should ever be delivered, and so there was no consideration of the circumstances of any individual case, because he just wasn't going to give it ever. There's another case in the Court of Appeal, in this court called Coulter, where the court said, I always exclude evidence that is the result of a discovery violation. I never give postponements, I always exclude. State makes a discovery violation, I exclude. Defendant makes a discovery violation, I exclude. I never give postponements. And that was also found to be an abuse of discretion of the variety of not exercising discretion. And that's because the court in that case, the same as Gunning, didn't consider anything about the individual circumstances of the case, just said, that's my rule and that's what I'm doing. And in this case, it's the state's position that there was more of a discretion given because the videos were looked at, because the court initially the day before, on August 1st, had an open mind about whether these videos were going to be shown to the jury, and looked at the excerpts and said, this is what I've developed as my best. She sort of goes through the difficulty in getting first audio and then video of witnesses and said, it's never been a good idea, I'm summarizing, it's never been a good idea, I'm not going to do it. There's going to be no exception in this case either. And I think in those circumstances, it's not the failure to exercise discretion, it's the exercise of discretion in the way that a particular judge has decided to exercise it in similar cases.
What in this case did the court identify as the individual circumstances that caused her not to deviate from her rule?
That, well, the same, she offered up the same reasons that she offered up in most cases, that it would give the jury the impression that we could come back and look at all of the testimony from all of the days of trial, and that it would inappropriately, and I think this is the one that really carries the most weight in my mind, it would inappropriately highlight certain pieces of witness testimony over others, and she didn't think that was appropriate. So I would change Your Honor's question a little bit, more so than identifying things that didn't make this case different. She identified things that made this case the same. And she said, I don't see anything different.
Well, my question was based on what you said the court
Oh.
did. So I was trying
Well,
to
then I may have misstated what the court did. The court said, I don't see any reason to deviate from what I've decided is my standard practice. I've applied this rule in my cases. I've done this in my cases thus far, and there's not going to be an exception here. So it was more about not finding an exception than saying, here affirmatively are the reasons that I think that this case warrants the application of the use of discretion that I've used in previous cases. And I would just point to the explanation that she gave for why she has developed that general best practice over time. So I'm sorry if I misspoke and confused you, but I think that that's the gist of my argument.
The court had a question for Mr. Ball along the lines of what have other jurisdictions done, if any, have spoken to this issue. Do you have anything to offer?
So I could find no case in any jurisdiction that held that it was an abuse of discretion not to allow this type of video to be played. But what I don't know is if there have been any rule changes to say, post those cases, this is allowed and these are the boundaries for allowing these sort of things to happen. So I guess the short answer is I don't know, but I do know that there has been no case that has found an abuse of discretion where a trial court refused to play anything, actually. I couldn't find a case that called it an abuse of discretion to refuse to play a video exhibit. The only cases that I have been able to find and that my friend on the other side points to are cases where the court said it was not an abuse of discretion to allow them to be played, which the state also agrees with. Thank you.
All right, thank you, Ms. Williams. Mr. Ball, how much time does Mr. Ball have?
Thank you. Getting back to the issue of whether it's an abuse of discretion to not exercise discretion, my friend in counsel tries to sort of soften it as a general philosophy or a general belief of best practice of trial counsel. That's not what it is. It's a rule of trial counsel. And frankly, by not having something from either the Maryland rules or from this court, each trial counsel is going to develop their own rules of the practices. Trial judge is going to create their own rules for how to handle these issues. The reasoning that was stated by the trial judge isn't reasoning that's going to change from any case. If the trial judge believes it's highlighting, then every case it's going to be highlighting unless it's, I guess, one witness in the trial. If the trial judge believes that it sort of shows the jury that they would be able to request certain portions of the testimony afterward, then every case would have that potential issue. So there isn't any discretion that's being used here. It's a rule that's being created by the trial judge.
But let's suppose that the trial judge's rule were, this really doesn't work most of the time because it's going to end up with both sides of the case wanting to incorporate additional portions of testimony so that the jury can see them or hear them. And the trial judge says, it would only be on an exceptional case that I would do this. What about this case is exceptional from the ordinary case that would justify a judge departing from a general rule of thumb?
Well, one, because this case is so dependent on the eyewitness testimony, and many cases are in some ways dependent, but most cases are, but it's so dependent on the eyewitness testimony, and there is, as was noted by Judge McDonald, there's cases in which they read transcripts, years ago, but and still today, but there's certainly a difference, and then of course I found a difference between from reading from a transcript, one, the attorney reading from the transcript isn't necessarily evidence. The words that are in it are evidence. The video, just as the video in itself, in this case would be evidence, but it allows the jury to not only hear the words, but to see, to observe. There's a reason why we have witnesses who come to trials, who sit on the witness stand, to allow the jury to look in their face, to allow the jury to read from their temperament, to read whether they're telling the truth or not.
So you would have this rule apply in all cases in which the factual testimony was disputed or was critical to the case? What was your exception again?
I don't think there's a reason to have any exception unless, one, there's some sort of time constraints where obviously you're not going to allow an attorney, you're not going to allow the state to say, I want to show 2 hours of video, and then the defense to say, well, I want to show 2 hours myself. Obviously, there can be time restrictions on it, or if there's an issue with somehow the video misleading the jury. And here you don't have any of those exceptions that are present. And it actually is, as friend counsel stated, in terms of the videos themselves, they were uncut videos to not alter it at all. And the reason it shows sort of going back and forth was that the videos were uncut. You can't sort of manipulate them because then that's changing it from the evidence that's there. The evidence is the trial testimony. But
you would say then that a judge cannot have a general rule to exclude this practice and make exceptions when appropriate?
A judge could do that, but that's an exercise of discretion.
Okay, so why is this case a reason? What in this case would give the judge a reason to depart from her general rule?
Because the length of the videos weren't very long, and it was something that did go to the credibility of the witnesses in which the videos were being used.
So credibility is key and length is key.
Correct. And here, as I stated, it was a hard and fast rule. I do not, under any circumstances, allow played video trial testimony in closing. And it was stated without, it's the practice of the trial court without exception. There's nothing in there that says, and I consider these issues in it. Trial counsel did note, these are the reasons why I have this rule. This is the reason behind the rule that I've created, but it's not, in this case, I weighed these factors and decided that I'm not going to.
On that subject, Ms. Williams makes a point when she says that the judge, the day before, said, I'll look at this tonight. I guess, I don't have verbatim what was said at the time, but essentially, I'll think about it.
What the judge said, and I don't believe the trial judge completely understood what was being submitted in terms of the videos, because there was a video, one of the videos that was submitted was portions from Mr. Johansson's statement to an officer before that was submitted in the evidence, and the trial judge said, you're able to show his video in closing argument. You're able to show segments from that video, but the distinction was made from the trial testimony.
Did the judge decide that piece of counsel's request on the first of the 2 days that we're talking about?
That was actually on the second day. When we came back, the trial judge said, I'll let you show the video from Mr. Johansson from his statement that was admitted into evidence, but not under any circumstances testimony in trial. So it was a rule that was made about the trial testimonial videos as opposed to other evidence.
Okay, on this subject, what did the judge say she would undertake? I'll look at this, or I see it's part of the package, but we're just trying to get a sense of, at least as you, from your perspective, you're saying we have a failure to exercise discretion.
Yes.
Now, maybe we do, maybe we don't, but I'm trying to discern exactly what was said in response to counsel's request when.
So at the end of the first day, I said, Your Honor, I would like to submit certain videos from closing. And it wasn't, and there was some mention of there being trial videos, but not, specifically, this is what I'm submitting. I'm submitting actual videos of trial testimony, and or from which witnesses. So the videos that I intended to use in closing argument were submitted to the court, and the trial court looked at them and said, none of these videos of trial testimony are coming in.
Okay.
But I'll make a distinction for these videos from this other piece of evidence that was put in.
The judge said that the following day?
Correct. After reviewing the videos and said
So in some respects, one might say she was not caught unawares or surprised, but it wasn't laid out exactly what she would be seeing.
correct.
All right, thanks, that helps
And-
this judge at least. Mhm.
Yes. And with that, I do believe that there was an abuse of discretion in this case, and that for the reasons as stated and the reason in my brief, that abuse and the error that was there was not harmless beyond a reasonable doubt.
All right, thank you. Counsel, well argued, interesting case. The court will take a short break and ask that the attorneys in number 16, McDonald versus Harford County, be present at council table.
All rise.